It was nice meeting all your clerks.
All right, let's go ahead and get started. We're calling the docket. If you could go ahead and announce the case name, Mr. Starling.
Yes, Your Honor. This is cause number DC 20-14550. Joshua N. Terry is trustee for the La Jolla Trust v. Abraham Abdo and Arania Abdo. Brandon Starling and Timothy Zeiger on behalf of the plaintiff, Your Honor.
Okay.
Your Honor, Richard Hathaway, on behalf of the defendants, counterclaim plaintiffs, and third-party plaintiffs, and I'll refer to them as the Abdos throughout the hearing.
And we're not expecting anyone else here for this hearing besides the two of you guys?
My associate, Stephen Court's here as well. He's just a bit off the side.
Timothy Zeiger is supposed to be here, Your Honor. He was here originally, then he's disappeared.
Do you want to call him? I don't want to start without him if he's...
Let me email him. He's in mediation, so he stepped away from that to be a part of this. Hold on just a second. Just sent him an email. But Your Honor, we can start without him. If he can join, that's fine. I was going to do the argument anyway.
Okay, let's go ahead and proceed.
So, Judge, I'm just going to give you a little bit of background on the case so that you can understand kind of how this discovery dispute arose and why the information that we're seeking is relevant to our claims in this case and our defenses as well, Your Honor. On September 14th, 2020, the trust, through its trustee, entered into a contract with the Abdos for the purchase of a house. My client, the trust, was selling the house. The Abdos made an offer that was accepted on September 14th, 2020. The home was the primary residence of the beneficiaries of the trust, who are Joshua and Jennifer Terry. Pursuant to the contract, it's a standard TREC contract, Your Honor, the defendants had the option to inspect the home and to terminate the contract within 12 days of the contract if they found something that they didn't like. They did at least 4 inspections of the home, and on September 24th, there was an amendment made to the contract which ended the option period, and they purchased the home at that point as is. Closing was still a couple of weeks away. On September 23rd, our clients provided a survey of the home. The next day is when the contract was amended to go ahead and finalize it and go ahead and move forward. On September 28th, the defendants were provided with the title commitment and the exception documents. And pursuant to the terms of the TREC contract, the defendants had 5 days from the receipt of those documents to lodge any objections to any defects or exceptions or encumbrances to title. On October 1st, just a few days later, defendants made certain objections to the title commitment, but the title company rectified those. But through their realtor, they then attempted to make a number of other objections based on alleged misrepresentations, alleged defects in the home, things that should have been addressed during the option period. Only one of the issues actually had anything to do with the title commitment or the survey at that time. So pursuant to the terms of the contract, my clients at that point would have had 15 days to try to cure any of the objections. Well, instead of giving us 15 days, they gave us less than 2 hours and then unilaterally canceled the contract. In fact, we didn't even respond to the objections. They just went ahead and unilaterally canceled. So my clients filed suit on October 2nd, seeking specific performance and alternatively monetary damages as a result of a breach of contract. The defendants asserted some counterclaims for fraud and a deck action. And so here we are. Part of what our discovery, we served discovery back in early October. Part of what our discovery is trying to get at, Your Honor, is what are the real reasons that my clients believe this is subterfuge, this is pretext, that they're, because of the way the objections were structured, only one of which had anything to do with the title, and the fact that they didn't give us the 15 days to cure, My client sent a number of requests for production interrogatories asking, okay, provide us with your communications with your realtor regarding the contract, regarding the property, provide us with any other contracts you entered into within that 3-month window between, I think it was September 1st and November 30th, just to see if there's any other contracts. Is there another reason that you guys actually tried to cancel the contract? Because my clients had a hard time believing that the objections were anything other than frivolous. So the defendants in response in December lodged a number of objections, and in particular to any contracts, any other contracts that the parties may have entered into, or any other offers they may have made on the home. But they also made a number of privilege assertions with regard to communications with their attorney. I'm sorry, communications with their realtors. Specifically, they alleged an attorney-client privilege with respect to not only communications with their realtors, but their realtors' communications with an individual named Mark Gibbons. Mark Gibbons is a former Texas attorney. He hasn't been licensed to practice law since 2004 in the state of Texas. And he is one of the individuals that apparently reviewed the title documents, made some objections, and Mr. Abdo, Dr. Abdo, actually forwarded his email containing those objections to our client, voluntarily disclosed those alleged privileged communications, although you'll see in our motion to compel, Your Honor, we feel that since Mr. Gibbons was not an attorney, that those are not privileged communications. So there was that. There were also privilege lodged in response to just mere communications between the realtors and the Abdos on which no attorney was copied. There's at least 6 documents, 6 email or text messages going back and forth between the Abdos.
What would be easier for me at this point would be is if you could kind of just show each individual request, and let's just argue through them one at a time, sure, as opposed to just kind of, I understand what the case is about.
That's fine.
But why don't you share? I'll go ahead and enable it. Go ahead and share screen.
Okay.
Each individual request, and then we can argue about it if we need to.
Sure. On page 15, I don't know if Your Honor, we had a hard copy delivered to the court. I don't know if Your Honor actually got it.
I did not. Unfortunately, I don't know if you guys heard, but the jury trials were canceled this week due to the COVID upsurge. And so I'm actually at home right now, so I did not get it. I apologize. So if you could just share screen.
Sure.
Right.
Yeah, let me see if I can share screen. It's been a while since I've done this. Hold on just a second. Okay. Okay, Your Honor, I'm gonna, let me see if I can do, typically what I've done in depositions is I've just attached it in a chat. Would it be easier if I did that?
No, if you could share screen it.
That's fine.
That would be great. Let
me try to do that right now.
We just have to click the document and it should come up.
Okay. You see that?
So that's the first request?
That's correct. So,
okay, so request number 1.
Yeah. All written communications, electronic paper, written summaries of any oral communications.
I got it. Mr. Hathaway, what's your response?
Your Honor, this is in connection with, I'm just trying to get the issue so I can determine which one it is we're on. Yes, Your Honor.
It's on the screen.
I see that. Thank you, Your Honor. This goes to their to the non-party subpoena requests number 1 through 2, which I have down, Your Honor, as issue number 3, specifically concerning attorney-client privilege, client representative. And Your Honor, I can jump to that if you want to share screen. I can happily go through that with you.
Wait. So what we're talking about is in plaintiff's request number 1 and 2 of the subpoena served on defendant's realtor, DPM, plaintiff seeks to file it. Okay, so you're right. It's part of the document. So I just want to hear your argument. I don't need to share screen or anything.
Okay. Well, Your Honor, in this instance, these both concern privileged communications with a client representative, and the
A privilege for who? Who's the? Is there an attorney involved in all this, or?
Your Honor, pardon me, just give me just a second. It's, I do have a screen, a presentation for that, Your Honor, to kind of walk you through it, but I can jump straight into it. So, Your Honor, Rule 503 it outlines the lawyer-client privilege, and A is basically the between the client or the client's representative and the client's lawyer or the lawyer's representative. And D is between the client's representatives or between the client and the client's representative. That's Texas Rule of Evidence 503 B1 A and D. And so, Your Honor, those concerning your question about the fact that there's communication between the abdos and the realtor, as you could see from 503 B1D, a client representative can just be the client and the client's representative. The client's
have any cases ever applied? I've never heard of any that have applied this to a realtor.
Your Honor, as it relates specifically to a realtor, we didn't find one specific to a realtor, but we did cite authority supporting the application of the privilege, particularly in connection with, we did cite cases concerning an investment banker, also teams, an investigation team as well. And the definition of client, of the actual privilege itself and what it applies to specifically provides that their communication can be between the client representative and the client. And that could be privileged, assuming, of course, it is treated as privileged. And we do have evidence, Your Honor, attached to our pleadings. And the definition of client representative.
Have you done a privilege log? Have you already done a privilege log?
Yes, Your Honor, there are 2 privilege logs on file, Your Honor, because, for example, this particular part here that we're looking at on the screen, this concerns the subpoena for the non-party realtor. But they also raised this issue because they have similar, if not almost identical, requests to the abdos, where we have provided a privilege log for the abdos specific requests as well.
And you don't have a single case that has applied this privilege, attorney-client privilege, to a realtor, is that correct?
To a realtor in a real estate context? No, Your Honor, we don't have a case directly saying that a realtor.
And are there any cases or any of the communications here that are responsive to request for product number 1? Is there an attorney involved?
Yes, Your Honor. In fact, we've got, there's tons really. Defendant's Exhibit 7H, which is the DMP privilege log, identifies 49 documents, Your Honor, that are between the KRCL.
Go ahead and share screen all of the documents you have responsive. You say there's a privilege log. Go ahead and share screen the privilege log.
Oh, okay. Let me jump to my presentation, the slide that kind of helps us here. Pardon me. Let me share screen here. Let's go to screen 3. Can Your Honor see the screen?
Yes.
Okay. And what we have here is this is the third issue about the client representation privilege, and it talks about the scope at the very top. But the amended privilege log, Your Honor, which is Defendant's Exhibit 7H, identifies 49 documents that involve KRCL attorneys and either the realtor directly or the realtor in the abdos, all in one communication. There are only 5 documents concerning Mr. Mike Gibbons, which we're happy to get to that issue next as well, once we get to those specific requests. But there's also 6 documents between the abdos and the client representative alone. And in some of those, they're referring to things that need to go to KRCL or Mr. Gibbons. And that's identified in the amended DMP privilege log. And that's the privilege log for the non-party subpoena that we're looking at now. We also have, Your Honor, a Plaintiff's Exhibit 6, which is the Abdo amended privilege log that has 32 documents between KRCL, the client, or the client representative, 8 with Gibbons and the Abdos, and 6 between Abdos and the realtor. And Your Honor, this client representative is it's expressly included within the scope of the rule. And it allows for there to be communications, even investigations in connection with either litigation or anticipation of litigation. And it's clearly within the scope of the rule. We did provide authority in the briefing in response. I did not, for some reason, I did not include it in my my presentation here, but we did provide 2 cases we believe are directly on point, to which we received no response, that outlined and indicated instances in which a client representative was established and proven to exist under the rule, and the privilege was extended to them in connection with communications that were meant to be confidential and were for the facilitation of legal services, which is what we contend occurred here.
All right, let's break this down then. So there's 49 documents where Kane Russell, there was communication between Kane Russell, the client representative. I mean, I think that's probably going to be privileged. There's 5 documents between the client representative and Mike Gibbons. Gibbons is the real estate agent.
Yes, Your Honor. Also, pardon me, Your Honor. Mike Gibbons is the attorney that the Abdos had a reasonable belief to understand he was an attorney.
But he was not an attorney. He
lapsed, his license lapsed, Your Honor. The plaintiff has asserted that it lapsed in 2004, but we couldn't find any evidence to support that. We do know that it has lapsed. We've verified that, but our client did not know that at the time. And the standard is not, it isn't necessary.
Do you have any cases that have extended the attorney-client privilege to an unlicensed attorney?
I absolutely do, Your Honor.
Okay.
Yes, Your Honor.
Go ahead and share screen the case so I can read it.
All right. Let me see if I can get to that. Let's see. Case law. So I've got 2.
Do you want me to unshare screen this? That might be helpful.
If you want to unshare it, then we can reshare it and I'll jump back in to just change the screen if that helps. So share screen number, I guess we'll go with number, I'll move it to number 2. I'm going to go to screen number 2. There's 2 cases, Your Honor. Henry Silver is a Texas Supreme Court opinion. We can look at that second, but this one is this case is 1998. It's Corpus Christi, and go through the analysis here. And it's talking about the attorney-client privilege here, where we start to do the highlighting. Furthermore, although the issue is not before us today, our holding does not jeopardize or compromise the lawyer-client privilege. By definition, appellants occupy the status of client and martial lawyer for purposes of the attorney-client privilege. And when you see the rule there, as you continue on, let's see. Client is defined under 503A1. Then you can go further down. Lawyer is defined under 503A3 as, quote, a person reasonably believed to be the client to be authorized to engage in the practice of law. So the standard being reasonably believed by the client. And that's one particular example.
Can you go down a little bit so I can see there's a little more? Beyond.
Certainly, please go ahead. In this particular instance, Your Honor, they found that in fact, in that particular instance, the person was aware that the license was suspended. In our case, Your Honor, that's the evidence, the undisputed evidence from Dr. Abdo, is that he had no idea and that even suspected it until he received the October 2nd email from the trustee, the plaintiff. So the standard being he has a reasonable belief. And the Silver case, Your Honor, it says that the rule does not require there to be a lawyer. It just simply says that in a general way. It says, and the reason is, of course, it's like I said here, is a reasonable belief. That's as to Gibbons. The other part, Your Honor, is the declaration, pardon me, the disclosure responses provided by both the plaintiff and the third-party defendant have identified Mr. Gibbons as the attorney for the Abdos during the transaction. So even their own discovery answers admit to the fact that yeah, they believe he was an attorney as well. Again, the standard is reasonable belief that this person is an attorney. And in this instance, the evidence shows, Your Honor, from Dr. Abdo, and I can jump down to that slide to show you what we just did was cut and paste out of his declaration. But he had known, the Abdos knew Mr. Gibbons for 20 years. And for the last 10 years, had been working with him on addressing legal advice and helping them with legal advice. If Your Honor wants to share the screen with me, I can show you some of that.
Yeah, you can share a screen
to help you. Thank you. So we're going to go to, I believe it's number 20, page 26. All right. So, oops, sorry about that. From the beginning, we're going to go back to 26. Pardon me for jumping around, Your Honor. I appreciate your patience. Here it is, Your Honor. Evidence of reasonable belief. What we did was we cut and pasted from the declaration verbatim. And Dr. Abdo's declaration, paragraph 3 and paragraph 4, walks you through the fact that they've had this relationship for 20 years. And he's given very specific examples in which he obtained legal advice from Mr. Gibbons. And it includes this particular situation. In paragraph 4, it's based on the long-standing relationship. In September and October, they asked for legal advice on it and they obtained it. During that time, he didn't question Mr. Gibbons regarding his continued eligibility to practice law in the state of Texas. When seeking legal advice concerning the property, had no reason to believe Mr. Gibbons was not authorized or otherwise ineligible to practice law in Texas. And paragraph 5 is he did not know he was not eligible until October 2nd, 2020, and that's when he received the letter from, the email from Mr. Terry. So in this instance, Your Honor, it's that combined with, of course, Defendants Exhibit 11 and 12, pages 5 on both, they've identified Mr. Gibbons as an attorney as well. Again, the standard is not a massively ardent one. As Your Honor is aware, for me to assert the privilege and to establish a privilege. So we look at the burden of proof I've got on page 16 of this presentation here, and I think it's helpful because this isn't something that has to be, we don't have to establish, conclusively. We have to present evidence, a minimum quantum of evidence necessary to support a rational inference that the allegation of fact is true. That's from the DuPont, Texas Supreme Court 2004 case. And once we do that, once we have met our prima facie burden, Your Honor, as you see on the right-hand side, once we've met that burden, then it shifts to the party seeking production to refute that claim of privilege. And Your Honor, we believe as it relates to both the client representative, which is evidenced by the declaration from Dr. Abdo, it's represented by the agreement between the parties. It's
okay. I get it. Response.
Yeah, Your Honor, just a number of things. So it's settled under Texas law that there is no presumption that documents are privileged, and there's no presumption that a party listed on a privileged log is an authorized person under the rule to receive confidential communications. We'll talk about Mr. Gibbons specifically, but the problem with the defendant's evidence today is it's his burden to present either by affidavit or live testimony evidence supporting the privilege. If you review their affidavit, it does not meet the requirements. We briefed this extensively in our reply, which we forwarded to Your Honor today. In beginning in paragraph 9 on that reply, there's a number of cases in that brief that say, here's what the standard is, and this is why they didn't meet it. The defendants are required to specifically identify each document in the affidavit at a minimum, and the affidavit must identify the documents or group of documents in such a way as to allow the plaintiffs to assess the applicability of the privilege and establish proof of the privilege. what your honor will see if you review the affidavit, or when you review it, is that first of all, there's like 3 lines with regard to, the confidential communications with the realtor. It just basically says, I had confidential communications with my realtor. And that's not the standard. The affidavit has to show that the communications were kept confidential, were not not intended to be disclosed to third parties. And if you review,
I need to just let me go ahead and make a ruling on this. For any communications between the party representative and the realtor, just between the 2 of them, that needs to be produced. Anything that's between involving KRCL and where KRCL is, or Kane Russell's involved, that would be privileged, or at least arguably privileged. I could do it in camera inspection if need be, but that's going to probably be privileged. And then anything involving what's his name, the disbarred attorney, Gibbons. That's going to be. I'm going to hold that they've met their prima facie case. And so, if you want to do additional discovery, take Gibbons' deposition, take the client's deposition on the issue of when they knew that he wasn't when he was disbarred and what their expectations were. You can do that, but at this point, I'm not going to order it to be produced. Let's go to the next one.
Your honor,
let's go to the next one.
Okay. That's the majority of the communications that are at issue. The one with Gibbons is the one where we've claimed he's waived his privilege by disclosing those communications. That's Exhibit 12 to our motion, and it's also there's another disclosure on the reply where he's basically, or I'm sorry, there's another one. I think it's Exhibit 14 to our motion to compel that is also a disclosure. We claim he's waived under Rule 511 of the Texas Rules of Evidence, the attorney-client privilege, by disclosing those exact same communications that he's claiming now are privileged. I know your honor has made a ruling, but if your honor would review those communications and maybe at least make an in-camera inspection, and reconsider that potentially he has waived that under 511 by his voluntary disclosure. We briefed this extensively in our reply and feel that he's done so.
I have not seen the reply, so I haven't looked at that. If you filed it today, I have not seen it.
Yeah, it was actually filed Saturday, but it's probably not in there today. I sent a courtesy copy to your coordinator today. But again, those two exhibits are attached to our motion to compel. One's Exhibit 12. I think the other one's Exhibit 14. So if your honor takes a look at those, you can see that the communications with Gibbons, Dr. Abdo said, forward my communications with Gibbons to their attorneys, or to the Terrys. And so, we think that's so there's certain communications, I guess, that you've already received. Is that the issue that you think they've waived? We think they've waived it because we've already received a communication from Gibbons to Dr. Abdo that Dr. Abdo said forward to the other side. So our position is based on what they've done, based on them forwarding that document. And there's another one as well. There's 2 documents.
Any document where there's been a voluntary disclosure, obviously that the privilege would be waived.
We agree, your honor, and that's the issue, and that's the issue with Exhibit 12 and the other exhibit is we believe that they've waived their objections, the assertions of privilege because of that. So that's extensively briefed in our motion and in our reply. And there's also examples, obviously, Exhibit 12 and Exhibit, I think 14 was the other one, your honor.
Your Honor, may I very, very briefly respond?
Okay.
Your Honor nailed it right out of the gate, and that is that the email that was forwarded on to the other side that basically included the objections verbatim made by the attorney. Okay, that document, we don't claim a privilege to that. In fact, that has been produced. Every version of that has been produced in the case. That's not the issue. What Mr. Starling is asserting, your honor, is that because of that forwarding, they're trying to claim that it applies to any communications concerning the objection, any communications concerning the property, any communications concerning, basically.
It's only the documents that have been voluntarily disclosed. So anything that's been voluntarily disclosed, the privilege is waived. It does not include any communications that have not been voluntarily disclosed.
Well, none of the things on the privilege log, your honor, within that scope.
Well,
okay.
Your Honor, the subject matter, we don't know from their privilege log whether there's any subject matter communications between the Gibbons and the realtor regarding the objections, regarding the title. All of those, we argue in our motion, have been waived due to the fact the voluntary disclosure of the objections. There's case law that says if you disclose a communication on a particular subject matter, it's possible that you've waived your communications on that subject matter because of that voluntary disclosure. And we cite those in our motion, Your Honor. It's also in our reply. So that's our position, is because you've chosen to have a select, few that you've disclosed on the subject matter of the title commitment and the objections. You've now waived all of them. You can't do an offensive use here and use it as both a sword and a shield by going ahead and disclosing certain communications that are beneficial for you, but then withholding communications that aren't.
Response.
Your Honor, the offensive use doctrine is a very, very different doctrine, and that's not that wasn't argued, laid out, or established. The numerous elements related to that, and we have not in any way attempted to offensively use anything and then keep it privileged. Again, the cases that they cite, Your Honor, one, for example, was a communication by the State Bar to a committee of the State Bar to an attorney that was considered to be confidential and privileged. Because there was testimony by the attorney substantially about the contents of that document, the court found in that instance that the attorney waived the privilege, period. And so there's a disclosure about that specific document, though. That's the point. It goes to the specific document, as Your Honor's already noted. It doesn't go to other topics.
I guess theoretically, I haven't seen the reply. I can't find it online either. And so if they're I guess my thought is if there's particular documents that let's say within the voluntarily disclosed documents, if there's something that they referred to, like, hey, as he said in this, July 27th email where he analyzed all this, we take the following position. If it's referenced within there, potentially, I guess it could be more of a disclosure, but at this point, I haven't seen the reply, so I don't know exactly what's in there. It's not even online, so that I could see. So what else do we have to discuss today?
Your Honor, that encompasses a large number of the communications. If you want me to share screen, I can do that real quick.
Go ahead.
Let's see. Okay, so that's we've already talked about 1 and 2. Let me get down to 13. I won't read that for Your Honor unless you'd like me to.
No, you don't need to. All right, response.
Your Honor, number 13 appears to focus in on the only communications in there that would be privileged, Your Honor, that we would have asserted have to do with communications between the Abdos and their realtor in connection with any of these, particular issues, also aligned with the lawsuit. So that's why we asserted the privilege to number 13. It's so broad and not limited in time and scope that it would inevitably include some of those documents. And so that's why we asserted that the privilege, the client representative privilege, to number 13. The fact that it excludes, for example, Mr. Gibbons or the Abdos counsel is what leads us to that one limited area, Your Honor, the client representation privilege relative to the Abdos and the realtor. That's what remains.
And Your Honor, this is not communications with any attorney. This is strictly with any third party. I mean, you'll see in there, we exclude Mark Gibbons.
The objection's overruled. You need to go ahead and provide any responsive documents. What's next?
Next is request 5 and 6. Again, those are in regard to Gibbons. So I think that Your Honor has already issued.
I've already ruled on this.
Yeah. All right. Number 7 is particularly important, Your Honor. All contracts or offers, agreements between the period of September 1st, 2020 and November 30th, 2020. That's the 3-month period in which, it's sandwiched their offer and contract with our client. Our position.
I'm going to order this to be produced, but it says purchased of a home. I'm going to limit it to just purchase of the home at the basis of this suit.
So, Your Honor, the reason that we're asking for any homes is because our position in the original petition is that their objections are pretext, that they either found another home or they had buyer's remorse. And so if they had another offer or a competing contract going on and they decided, hey, we didn't really like that home, we like this other home. And Your Honor, we've already, in our reply, you'll see, and in our motion to compel, you'll see, we've already pointed to, we found basically what we feel is the smoking gun in this case, Your Honor. An email from Mrs. Abdo to the realtor that basically says they've had buyer's remorse. It's not any of the reasons that they are that they've asserted as objections. It's because this house is going to cost too much to fix up. So let's see if we can think of objections. So we feel that there's already a basis here that's been established in both our motion to compel and in our reply, that you'll see that there are very relevant communications. And that says that there's another reason that they canceled this contract. It had nothing to do with the objections that they asserted on October 1st.
All right, response.
Your Honor actually nailed it right out of the gate when you limited it to the home and the property. This case focuses in on anticipatory breach of contract. That's their claim. Then our claim is we were fraudulently induced. Once we learned about your fraud, we're not required to ratify your fraud, and we terminate. So that's really what you're fighting against. There is no authority that they cite, nothing that could support the proposition that the Abdo's motive, other than what's actually stated concerning fraudulent inducement, is in any way relevant or applicable here. Any other property or home, as Your Honor has pointed out, has nothing to do with the Princeton property, period. And whether or not they
okay, I think I may have made a mistake here. Abdos is the buyer, right?
Yes, Your Honor. Yes,
Okay.
Your Honor.
Yeah, I'm sorry. I was thinking he was the seller. So Abdos is the buyer. I'm going to just overrule the objection to this. I think that's I understand why that would be for the buyer, why you'd want to look for other ones.
I'm sorry, Your Honor, I missed that.
I'm going to overrule the objection and order 7 to be produced. On 11, I'm also going to overrule the objection and order 11 to be produced. What else do we have?
Your Honor, on number 11, it's moot because it's already been produced.
Okay.
I just meant to respond to that.
Well,
one other thing, Your Honor, I wanted to point out that because there are other requests that are like this that I think that I have concern about. Again, and if we could share screen, I'll show you. We do have a discovery answer that kind of demonstrates that there isn't any. There are no other agreements or purchasing agreements executed other than one back in March of 2020.
So Your Honor, if there are no documents, he can say after a diligent search, there are no documents.
Yeah, there's no documents.
Well,
I'm just overruling the objection, ordering anything in your care, custody, and control to be produced.
Okay.
So we can skip. So 37, Your Honor, they didn't lodge an objection, but they claimed that they allowed the realtor to produce every document responsive to these. So we can skip these 3, 4, 8, 9, and 12. Yeah. Okay. So part D, Your Honor, is they have. So one of the issues in this case is in the privilege log. In the privilege log, instead of identifying what the substance, not the substance, but the subject matter of what some of the documents were that were redacted, they claim they put, these are screenshots. We don't know what they're screenshots of. So the problem is what we found out is that they were actually claiming that documents that were responsive to our subpoena, including the smoking gun document that I told Your Honor about a while ago, they claim that those are screenshots without disclosing that they're actually text communications between Dr. Abdo and the realtor that prove pretext. And so they have alleged, they've removed that privilege objection with respect to some of the documents, but then on DPM 539 and through 541 and DPM 543, 551 that are right here, Your Honor, those specific documents, they identify them as screenshots without saying, no, those are text communications, or those are, those are email. So we have no clue what those are. And the only basis for withholding those documents is not an assertion of privilege. It's just they claim that they're irrelevant. Well, Your Honor, the realtor's attorney produced those documents in response to our subpoena. So obviously he thought they're relevant, and I don't think they should be able to withhold those documents and redact those documents, especially when they're not telling us what they are in their privilege log on a mere relevance objection. Those could be, like the other document that we found, as we briefed in our reply, more relevant communications between the Abdos and their attorney. Like, again, they tried to hide a relevant document behind that assertion of privilege, and by claiming it's a screenshot. We would never have known if they hadn't inadvertently produced one page of those documents. So we believe we're entitled to see DPM 539 through 541 and 543, 551, especially since it's just a relevance objection that they're asserting. And it's communications between them and their realtor, which, by the way, Your Honor, they've asked for every communication between us and our realtor, and we've produced them. So we feel like we're entitled to these documents.
I'm a little unclear what, okay.
Your Honor, I'm happy to address some of this, but
Yeah, go ahead. I'm not sure.
We're taken aback by this assertion that we've hidden or done anything improper here. The screenshot is actually the subject line of the email at issue. And this does concern, what ended up happening was, Your Honor, we asserted a privilege for the realtor and his counsel. The realtor and his counsel waived the privilege. We then amended a privilege log and supplemented the production to include those documents that the realtor decided was not privileged anymore. And the realtor at Plaintiff's Exhibit 5 clearly indicated that when it produced these documents back in April of 2021, that it was withholding those documents that we had identified, those categories we had identified and worked with them on in connection with our motion for protective order that was filed 2 days earlier. So we have supplemented, we have produced, we have in no way hidden anything from them. And the fact that they have it and they're trying to assert and stack inference on inference to try to say we've somehow done something improper is, I've never even been accused of that prior to receiving the third amended motion to compel. But beyond that, Your Honor, and focusing in on what's at issue here is that the court has already ruled on these to the extent that it has to do with communications between Ryan Chief and the KRCL or something to that effect. And Your Honor's already ruled on the privilege issue altogether. So they're trying to go back to this, and now they're trying to basically besmirch us on this and kind of steer the issue away from what's actually.
My previous rulings will stand and apply here as well. What else do we have?
Okay, and Your Honor, just there's not much more, but just for clarification, that those will be produced because they're just communications between the realtor and the Abdos. That's what I understand your ruling. Okay,
correct.
Great. So a couple more things. So the plaintiff's motion to compel production of text messages between Dr. Abdo and Ms. Struff. I think you've already asserted that those should be produced. Ruled on that. Okay. Plaintiff's motion to compel full and complete answers to interrogatories. Yeah. Okay. So number 14, Your Honor, we've asked them to identify the individuals who prepared the defendant's initial offer. There has been a claim by the defendants that this contract is not valid because a trust can't enter into a contract. We've briefed that extensively. They filed I think a plea and abatement on that issue, which we responded to. We're trying to find out who actually prepared this contract and the offer that was made to us. And clearly that's something that's within their constructive knowledge. They just have to pick up the phone and call the realtor. But they're refusing to disclose that information.
Right. The objections overruled. You're going to be ordered to provide an answer.
Your Honor, may I briefly respond? Well, if you look at the interrogatory itself, we do respond. We say subject to and without waiving the foregoing objection. Defendants believe that the initial offer, including the specific sections above, was prepared by someone at the office of Dave Harry Miller.
If that's your answer, that's fine. Just the objection's overruled.
That was our answer. Thank you, Your Honor.
Objection's overruled.
And Your Honor, we've asked for him to identify the individual. They can pick up the phone, call Ryan Strife, and find out if he prepared the offer. It's within their constructive knowledge. That's what we've asked for. I mean, them just saying, oh, it's somebody at DPM. I mean, they ought to know by picking up a phone.
Your Honor, an interrogatory answer is based on the information that we have available at the time, but that's the information we have available at the time. And in fact, it's based on our belief that that's what happened. We don't really know.
Guys, let's move on. I've ruled.
Okay, thank you.
Your Honor, I don't think that there's anything else that's before the court. We did file a motion, a request for attorney's fees. I don't know.
It's overruled.
Okay, I figured.
Go ahead and at this point, go ahead and get me an order. Make sure that you share it with opposing counsel that details all of my rulings. At the beginning of the order, if it's agreed to, the form of the order is agreed to, it'd be great to have sign off on that. Make sure the beginning, instead of said on this date, say on July 26, 2021, the court made the following rulings. Email that to my court coordinator and to go ahead and e-file it as well.
Okay.
Your Honor, if I may, and I apologize for interrupting, Your Honor. I thought that there were other issues because we also had a motion for protective order and they raised issues in connection with our other interrogatories, for example, interrogatory number 20, for example.
We're not asking. Well, let me see. Let me look at that. Maybe I skipped over that one. Oh, I apologize, Your Honor. I did it. We asked for them to state the factual and legal basis of each of their affirmative defenses and identify the documents supporting that. I can share that with Your Honor.
That's fine. The objection's overruled, and you need to go and produce that.
So, Your Honor, if I may respond to that, if you look at the actual interrogatory itself, please state the factual legal basis of each of your affirmative defenses and identify all documents supporting same. Your Honor, Texas Rule of Civil Procedure 197, comment 1 specifically identifies this exact type of interrogatory as improper. It says in the comment 1, and if you don't want to share screen, I'm happy to show you, says interrogatories that ask a party to state all legal and factual assertions are improper. And it gives you a comparison. It says if you're asking about a very specific item, a specific cause of action or specific issue, that is proper. But this goes beyond that. Also, because we have 8 different affirmative defenses, and if we have any other affirmative defenses that show up, this interrogatory would require us to respond to it. And lay that out. Additionally, Your Honor, I presented evidence in my affidavit of undue burden, which we also asserted as a response. And the cost for having to put together, go through each and every one of the thousands of documents that have been produced to identify each document that would support each of these 8 affirmative defenses would cost upwards of $25,000 to $20,000. And that's undisputed evidence. And up to this point, Your Honor, attorney's fees so far from our side have been around $60,000, a little bit more. So this would be a 33% jump just to respond to this improper interrogatory that is excluded by the comments in the rule. We ask that Your Honor sustain our objection.
Your Honor, I don't believe the rule says you can't ask what are the factual and legal basis of your affirmative defenses. The rule clearly says, Rule 197 clearly says you can ask contention interrogatories. We're asking for the factual and legal basis of claims and defenses. That's exactly what we've done here.
You don't have to marshal your evidence.
Right. And we're not asking that. We're just asking for what's the factual and legal basis of your affirmative defenses. And if there's documents that support them, then identify them. They've only produced I think their sides produced like about 900. In comparison, we were around 3,000. So it's not like there's 10, 50,000, documents here. They should be able to identify the factual basis of their affirmative defense. An interrogatory can clearly ask that.
Your Honor, if I may respond, and if actually we could share screen, I can even show you what it is I'm referring to in the rule.
Okay, go ahead.
So I cut and paste from the comment verbatim about, this is the comment 197, comment 1. Interrogatories about specific legal or factual assertions, and then it gives you an example, such as whether a party claims a breach of implied warranty, or when a party contends that limitations begin to run, are proper, but interrogatories that ask a party to state all legal and factual assertions are improper. As with requests for disclosure, interrogatories may be used to ascertain basic legal and factual claims and defenses, but may not be used to force a party to marshal evidence. Their failure to identify any specific any specific affirmative defense, Your Honor, requires us to do exactly that. This is a textbook improper request, period.
The comment he just quoted said all legal and factual assertions in the lawsuit. I'm asking for their affirmative defenses. There's only 8 of them. The idea that I had to specifically request in 8 different interrogatories, what are the legal and factual basis of your affirmative defenses, is, I think, counterintuitive. And I don't think that's what the rule entails. I'm asking for them to provide, to the extent they have a basis, tell me what the factual and legal basis of each of your affirmative defenses is. I'm
Your
not
Honor,
asking them to marshal their evidence. I'm happy to reform on the record that I'm not asking them to marshal their evidence.
Your Honor, that's precisely what they're asking for. Even in framing it so that we've only produced 900 documents, that's gross misstatement. Your Honor, we had to go out and get discovery from 4 non-parties by way of subpoena, because this outpouring and forthcoming of documents from the plaintiff did not occur until we found these documents from non-parties and started producing them. Thousands of pages of documents. Then we started receiving this supplementation from the plaintiff. But Your Honor, and that's the basis for why it would cost us so much to try to marshal it. Additionally, Your Honor, I mean, the rule says precisely what it says. And case after case clearly indicates that you're not permitted to just say, because here's the equivalent, Your Honor. If I went and sent them an interrogatory says, and they had multiple causes of action, it just said, provide for us a legal and factual basis for all your causes of action. That's prima facie improper right out of the gate. It violates the comment here. And so additionally, Your Honor, we have already actually provided them in our disclosure responses, which is attached, our amended disclosure responses attached to our responses. We've already outlined the factual and legal basis for all 8 of our affirmative defenses. This is a very extensive disclosure response. I think it's about 15 or 16 pages. I don't want to misstate that on the record, Your Honor, but it's in that range, and it does give a detailed, describe all of that. So, I mean, again, we have already done this. This interrogatory is out of the gate improper, and it require us to expend a significant amount of money in order to both answer all of the, identify all the documents that would support each of our affirmative defenses.
Your Honor, one final point. If he's already done it in disclosure response, then put it in response to interrogatory 20 and have his client verify it.
Yeah, that's kind of what I was thinking too. All right, I've made my ruling. I got to get to my next hearing, so just get me an order on this as soon as you can. It was great to see you guys. You guys be safe, okay?
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Good to see you.
Good to see you guys. All right, let me take a quick break. I'll be right back, and another hearing about to start. All right, guys, we can get back on.
Afternoon,
Good
Your Honor.
afternoon, Your Honor.
Afternoon. All right, let me go ahead and pull up the docket real quick. I think we're here on Compass Data Centers LLC versus Jonathan Trout. Is that correct?
That's correct, Your Honor.
Okay. And we're here on a summary judgment as well as a motion to compel, correct?
That's correct,
Yes,
Your
Your
Honor.
Honor.
Motion to compel is set first.
Okay. And who do we have here on that case? Mr. Hamada and who else?
Your Honor, Jeff Mills on behalf of plaintiffs.
Yes, Your Honor. And Sean Hamada on behalf of the movement and defendant Mohammed Votu.
And Mr. Myers, what are you here for?
Your Honor, I'm here for the 3 o'clock Win Oliver versus Juan Andreas Quillar.
Ms. Tremaine, what are you here for?
Nope. Hi, good afternoon, Judge. I'm just observing. I represent Jonathan Trout, a former party to this proceeding. He's since been non-suited, but I'm just observing the hearing out of curiosity. I asked Ms. Benson if I should use this link, and she said it would be all right.
No problem. Okay. Let's go ahead and go on the record on this. Let's go on the record on cause number DC 20-11957, Compass Data Centers LLC versus Jonathan Trout. Counsel, make your appearances.
Your Honor, Jeff Mills on behalf of plaintiffs.
Your Honor, Sean Hamada on behalf of the movement and defendant Mohammed Votu.
Let's proceed.
Thank you, Your Honor. Well, the good news is that since Mr. Votu filed his motion to compel on June 1st, Compass has stepped up its production of documents in response to the requests that were served way back on September 9th, 2020. We've received 5 production sets to date, mostly in mid-June and late June and early in late July. And we've also received corrected load files on July 7th, which was the day before my client's deposition, to their first 3 or 4 production. The problem was that we were not able to see attachments to emails. I can get into more technical detail if you want, but basically there was no parent attachment relationship. But that's been resolved. Plaintiffs have also made their damages disclosures as we've requested back on June 25th. But the issue remains whether Compass has produced all documents responsive to request number 1, 2, and 4 in our first consolidated discovery request. As you may know, Compass's petition makes very specific, serious fraud allegations, in fact, 11 of them at least, against Mr. Votu, and they're all concerning this third-party software called Digilux, which is spelled D-G-L-U-X. They make allegations that Votu represented, among other things, that Bitbox was not dependent upon Digilux, that Digilux was easily replaceable, that Votu and Trout were going to replace Digilux, and that Bitbox was built from the bottom of the stack up with Digilux as a replaceable piece. So naturally, we served discovery requests for Compass's information and documents evidencing all of these alleged representations that Votu made to Compass, allegedly, regarding Digilux. And these are the requests 1, 2, and 4, which mirror counts 1, 2, and 3 of the plaintiff's second amended petition. Now, as of today, Compass has produced more than 74,000 documents, but we've searched for Digilux in all of those documents, and there was almost nothing that predates the December 12th, 2017 transaction that is at issue in this case. There are maybe 6 emails from Votu to Compass that mention Digilux, but nothing contains the actual representations or even close to it that Compass claims that Votu made in their second amended petition. So what we want to know is this it? I mean, we don't know because the response to the request.
Is there a pending objection to those 3 requests?
They did make an objection, Your Honor, but they also stated that they would reasonably search for and produce responsive non-privileged documents at a mutually agreeable time and place. And so, we don't know if they produced all the documents responsive to the request or not. And we need to have them soon because the discovery cutoff is in December and we need to take Compass's deposition and obviously get ready for trial, et cetera, in this case. So all we really want to know is, look, if this is it, then just tell us on the record and we'll move on. But if there's more, then what we would request is that Compass produce documents in a manner that makes them identifiable per Rule 196.3C, that is labeled to correspond with the categories in the request. And, Judge, I don't see how it could be hard given the dearth of documents that they produced relative to those allegations to date. And they are the plaintiffs and they bear the burden of proof. We're entitled to know what they're relying on. And while it's true that plaintiffs are not required to marshal their evidence, they are required to have some basis for their allegations. And when their allegations include specific representations, they should be able to point them out without needing months to find them. So that's the basic basis of our motion to compel.
Response?
Yeah, Your Honor, a couple of things I'll highlight. First, we're not talking about 3 requests for production. We're talking about 200 requests for production, most of which were made in March. And plaintiffs have produced 133,000 pages. Most of those were in April, before the motion to compel was even filed. We also have voluntarily produced a number of documents from documents that we've collected from third parties via subpoena. Discovery closes on December 3rd. So we're not talking about just 3 requests for production. There's quite a few. And I'm happy to show Your Honor some examples. I know your docket's pretty tight today, so I'll try to move this along. But a few of their requests include every single email in Mr. Fotu's Google Suite account. Pretty much any email that Mr. Trout has ever sent regarding DG.
Mr. Mills, I'm a little unclear with what you're doing here. So he says there's only 3 requests and you're wanting me to compel on more than 3 requests. I would assume that you're trying to resist compelling.
That's correct, Your Honor. But to understand something, that they have given us multiple sets of requests for production, and we're trying to handle them all at the same time.
So you're trying to say that you've already produced your documents responsive to these requests and other requests? Is that?
We are still ongoing, Your Honor. We have produced quite a few documents. I believe that we will be done within the next month to produce all the documents, subject to our ability to supplement. But I believe that we will be substantially done and can amend our responses by the end of August to all 200 requests.
Okay.
Because I have to go through all of my documents for all requests, not just for a certain subset of the requests.
And for those 3 requests, he says are the last ones that are remaining. Is there any reason we still need an objection on those? Can we just overrule the objection and then you can answer those by the end of next month?
Yeah, I'm not withholding any documents based on the objection, Your Honor.
All right, I'll overrule the objection of those 3 requests and then go ahead and order those documents to be produced by the end of August.
Thank you, Your Honor.
All right, guys, sounds great. Anything else on the motion to compel?
Nothing, Your Honor.
Let's move to the motion for summary judgment.
Thank you, Your Honor. So as we just stated, do we need to make appearances again?
No.
Oh, okay. So as we just stated, this lawsuit primarily concerns a $4.3 million transaction in which the plaintiff's Compass data centers purchased 60% of Bitbox USA, which is a company that my client, Mr. Fotu, effectively owned 50% of prior to the transaction. Now, the contract that governs this transaction is the December 12th, 2017 contribution agreement. And that agreement is between Bitbox USA, which is called the company, Compass Data Centers, who was the contributor or the acquirer, Bitbox Holdings, and Mohammed Fotu and Jonathan Trout. And so Compass claims that prior to the transaction, as I just mentioned, Mr. Fotu made at least 11 representations that it relied upon, and they're all concerning that third-party software called Digilux. And I'll just skip past what examples of what those representations were that are in their petition. Article 2 of the agreement. So let me just tell you how the agreement is structured. Article 2 contains all the representations and warranties of the parties that were selling the assets. So that's Bitbox, the acquired company, and its owners Fotu and Trout, and also BitBox Holdings, which technically is the holding company that held all the membership interests in BitBox USA. Okay, so Article 2 are the seller's reps and warranties. Article 3 contained the buyer's reps and warranties. That is the reps and warranties of Compass. Now, not a single one of these alleged reps and warranty representations that Compass has alleged in their petition are contained in the 58-page contribution agreement. In fact, the word Digilux is not even mentioned in the agreement. And this is a fact that Compass can't dispute. So Fotu has moved for partial summary judgment on Compass's fraud claims. Again, those are counts 1, 2, and 3. And the grounds are that Compass could not have justifiably relied upon these alleged extra contractual representations as a matter of law. So summary judgment is warranted on these claims. And it's warranted for at least 5 important reasons, Your Honor. First, the contribution agreement is a valid and enforceable agreement that contains a merger clause. Secondly, the agreement was a product of an arm's length negotiation and the terms were not boilerplate. Third, Compass is a sophisticated party and it was represented by a sophisticated legal counsel. And in fact, let me just show you a quick slide on this, Your Honor. In section 3.05 of the agreement, Compass states that it had, and I'm paraphrasing here, that it had knowledge and experience in finance and business matters and was knowledgeable in the matters that were the subject of this $4.3 million transaction. Moreover, they represent in 3.06 of the agreement that they acknowledged that the Compass had been furnished and had carefully reviewed the information it deemed necessary to evaluate the investment in BitBox and had been afforded the opportunity to ask questions of Fotu regarding the terms and conditions of the transaction. I mean, that's what you would expect a sophisticated party like Compass to do, and they did. So the fourth reason, Your Honor, is that except for the representations and warranties contained in Article 2, Mr. Fotu, in section 2.24 of the agreement, disclaimed all liability for all reps and warranties or information made, communicated, or furnished orally or in writing to Compass. And lastly, Your Honor, in section 3.06 again, Compass expressly disclaimed reliance upon any representations by Fotu other than in Article 2. And again, Article 2 makes no representations of warranties regarding Digilux. So based upon these facts and at least 5 Texas Supreme Court cases, opinions, actually 6 that we cite to, summary judgment on Compass's fraud claims must be granted. I'll quote the court in Mercedes-Benz versus Carduco, which is a Texas Supreme Court 2019 case, because I think it says it best, and they're really quoting 2 other Texas Supreme Court cases, where they say, in an arm's length transaction, the party alleging fraud must have exercised ordinary care to protect its own interests and cannot blindly rely on the defendant's reputation, representations, or conduct, or the plaintiff's knowledge, experience, and background warrant investigation. And when a party fails to exercise such diligence, it is charged with knowledge of all facts that would have been discovered by a reasonably prudent person similarly situated. So that's a tough burden, I think, for Compass to overcome. But what they try to do is tell you that, well, Fotu's alleged misrepresentations are hidden in the language of section 2.19a of the agreement, and that the court needs to review and interpret a half dozen emails, documents, and presentations, only one of which, by the way, mentions Digilux, from the company's pre-contract negotiations, and to accept Compass's subjective opinion of what each such document says. But Judge, we all know that the parole evidence rule bars consideration of evidence of the party's substantive negotiations that results in an integrated, fully merged agreement. That's the Barrow-Shavers Texas Supreme Court case. Now, Compass also argues that the disclaimer it makes in this section 3.06 can only be enforced by Bitbox, not FO2, because it states that in the header of section 3, that the contributor represents and warrants to the company, which is Bitbox, and does not use the term equity owners as it does in Article 2. But Judge, in Article 2 is entitled Representations and Warranties of the Company, which again is Bitbox. And FO2 makes the representations and warranties on behalf of Bitbox. Because as we all know, a company can only act through its agents. Now, certainly FO2, who made these reps and warranties for Bitbox, is also the recipient of the reps and warranties made by Compass to Bitbox. Because to assume otherwise leads to an absurd result. If Compass's reps and warranties to Bitbox don't benefit Bitbox's principles, then they're merely illusory because no one then has the right to enforce them. And lastly, Compass claims that FO2 had a duty to inform it that its assumptions about Digilux and Bitbox's technology weren't correct. But the Texas Supreme Court has held that as a general rule, a failure to disclose information does not constitute fraud unless there's a duty to disclose the information. And whether such a duty exists is a question of law. Generally, no duty of disclosure arises without evidence of a confidential or fiduciary relationship. And again, that's the Mercedes-Benz versus Carduco case, Texas Supreme Court, 2019, that we cite in our motion for summary judgment. So in the end, Compass's many creative arguments, despite Compass's many creative arguments, the truth remains that Compass negotiated a commercial acquisition after a full opportunity for due diligence and with all the information it needed at hand. Compass agreed that the contribution agreement was fully integrated and that it was not relying on any reps, warranties, omissions, or information from FO2 other than those that are made within the agreement. And Compass fails to explain why. If it was so concerned about Digilux, it never sought to include anything about them in the 58-page agreement. I mean, Compass certainly could have requested or required such terms before executing the agreement and closing the deal. But that's Compass's failures and Compass's alone. And I'll just end with this quote from the Texas Supreme Court in the Forest Oil case. After the fact protests of misrepresentation are easily lodged, and parties who contractually promise not to rely on extra contractual statements. More than that, promise that they have in fact not relied upon such statements should be held to their word. We wholeheartedly agree, Your Honor, and the court should hold Compass to its word. That's why the court should grant FO2's motion for partial summary judgment on Compass's fraud claims. And with that, I'll pass the floor, but would like to reserve some time for rebuttal, Your Honor.
All right, you may proceed.
Your Honor, may I share my screen?
You may.
All right, Your Honor. Once again, my name is Jeff Mills on behalf of Compass Data Centers. And I would like to start off with a few key points here. The first is that Mr. FO2 cannot enforce this non-reliance provision, regardless of the contractual gymnastics we're hearing about the statements in the contribution agreement. The contribution agreement states that Compass was making representations to the company. Now, Mr. FO2 wants to say if it doesn't apply to him, then it's illusory and then no one can enforce it. Yes, Bitbox can enforce it. And just because Mr. FO2 may have been an owner at the time, that doesn't mean anything. And Mr. FO2 does not cite any authority for such. Second, Your Honor, representations made in the contract survive. And Your Honor, to be clear here, these were not representations and warranties on behalf of Bitbox. Mr. FO2 made representations and warranties about Bitbox. Those are two very different things. Also, lastly, Your Honor, this is a traditional motion for summary judgment. Mr. FO2 has the burden to establish there is no issue of material fact on the justifiable reliance element. And this includes the burden to establish that he fully disclosed all material information about Bitbox's IP. Now, Mr. FO2's counsel just mentioned something about a duty to disclose. There is a duty to disclose, and it was in the contribution agreement. Compass acquired Bitbox and EdgePoint, two sister companies, in 2017. Bitbox had a BMS, or a building management program, that it would use to sell to customers that could then monitor their small data centers and other building facilities. EdgePoint was a complementary addition to Compass's product line of data centers. Compass had made big data centers and EdgePoint designed smaller ones. And Fatu represented that Bitbox wholly owned the BMS platform with just a replaceable dashboard piece that relied on DG Lux. He also represented that Bitbox was developing a platform divorced from DG Lux, okay? And so what they essentially had represented to Compass, and this is the software stack that we reference in our response, is that this Bitbox platform was a software stack, the top of which is the dashboard. And the dashboard is something that the customer sees. And it was represented as a replaceable piece, and that DG Lux was just part of that top piece. And the rest of the software stack was Bitbox IP. This is what was represented to Compass prior to the contribution agreement being signed. Now, I agree, this particular graphic was something that was created after the contribution agreement, but it's a graphical representation of what was told to Compass prior to the contribution agreement. Now, what we're hearing from Mr. Fatu is the exact opposite. In his deposition, Your Honor, we asked if there was any other Bitbox created software other than the dashboard, and he said no. That's the exact opposite of what was represented to Compass prior to the contribution agreement. Now, when looking at the contribution agreement, Your Honor, there were a number of IP representations. Mr. Fatu does not and cannot dispute that, and that these were representations that Bitbox owned certain IP, quote, necessary for the operation of the business, unquote. And it included such terms as licenses, trade secrets. Am I not sharing, Your Honor?
I don't believe so. Let me.
Am I not?
No, you're not.
I apologize. I believe I thought I was. Hold on a second. Sorry, I apologize, Your Honor. Are you seeing that now, Your Honor?
Nope, we just see your computer. We can see it now.
Can you stop? You can see it now? Thank you, Your Honor. The contribution agreement made certain IP representations, intellectual property representations, necessary for the operation of the business. This includes things like licenses, trade secrets, proprietary information designs, etc. Now, this non-reliance provision that Mr. Fatu really harps on mentions specifically that Compass was entitled to rely on the IP representations that were made, entitled to, and are not carved out of the non-reliance provision, even if this non-reliance provision applies to Compass, which it doesn't. And there's also another very important provision to consider, Your Honor, and that's section 2.23. You will not see this section being discussed in Mr. Fatu's motion, and only a very, very small footnote in his reply, but this is a very important provision. It required Fatu to, he represented that he did not omit any material fact that could make any of the IP representations misleading. Now, starting with section 3.06, it does not apply to Fatu. Again, the contributor, which is Compass, represents and warrants to the company, and that's Bitbox. Now, the top part, Your Honor, this Article 3, representations and warranties of the contributor, and you see a similar type of a header on Article 2. Those cannot be used to interpret the agreement. That's also a provision of the contribution agreement, that the headings cannot be used to interpret the agreement. You have to look at the language. And the language says the contributor, which is Compass, represents and warrants to the company, and then made a number of representations, including 3.06. And Your Honor, this is not illusion. Compass had post-closing obligations to Bitbox, including to pay additional money to Bitbox, and that's section 1.04 of the contribution agreement. And Fatu's company remained a part owner of Bitbox even after the contribution agreement. And Fatu does not provide any evidence to the court that the construction is illusory at all. And additionally, Your Honor, Mr. Fatu's interpretation would render certain other contractual provisions superfluous. There is a disclaimer that Mr. Fatu makes in section 2 about representations he made. Now, in that particular disclaimer, there is no non-reliance language. And that reliance language is key, you see from the Texas Supreme Court, about needing to have that non-reliance language in order to negate justifiable reliance. Now, if the the parties, which clearly knew how to put non-reliance language into the contribution agreement in 3.06, didn't do so in 2.24. In fact, you wouldn't even need 2.24 if 3.06 applied. So Mr. Hamada's argument about the contribution agreement just doesn't hold any water because 3.06 doesn't apply and cannot be enforced by Mr. Fatu. At bottom, Your Honor, Mr. Fatu's argument is that none of the IP representations are about Digilux. Not that the contribution doesn't mention Digilux. He flat out states in his motion that IP representations can't be about Digilux. And the only thing that he offers is the contract itself. There is nothing about the circumstances surrounding the contract or definitions of the IP representations. Compass, however, furnishes that contextual evidence. In the Uri v. Kleber County case, Texas Supreme Court 2018, Your Honor, it talks about how, yes, you can't, the rules about contract interpretation are what they are, but language is nuanced. And this is straight from the Texas Supreme Court. And the meaning is often context driven. And that may include objectively determinable facts and circumstances that contextualize the party's transaction. Fatu represented to that BitBox owned all these licenses, trade secrets, et cetera, et cetera. Compass is trying to provide facts and circumstances to define those provisions, not augment, to not alter or contradict, to define, which is perfectly within their rights to do, and they should be given the opportunity to do. And Your Honor, when you really get down to it with the contribution agreement and the IP representations made in it, they do remain. Compass was entitled to rely on them and is entitled to sue for fraud. And Mr. Fatu does not dispute this conclusion. None of the contract provisions prohibited either. There are representations made, representations about the intellectual property, representations that Compass was permitted to rely on even if 3.06 applies. Summary judgment based on what's in front of the court right now will rob Compass of claims without any basis on those contractual representations. And Mr. Fatu does not cite to a single case that avoids that conclusion. The Texas Supreme Court.
How do you deal with Forest Oil on this?
In what particular way, Your Honor?
I mean, analyze Forest Oil and how do you distinguish it from the case of Barr?
I mean, I would distinguish it, Your Honor, because we're talking about the intercontractual representations. There were representations made in the contract. Forest Oil did not relate to.
Well, why wouldn't we grant summary judgment on any extra contractual representations and then potentially deny it on any contractual, representations made within the contract?
Your Honor, quite frankly, I don't know if the rules allow such a judgment to be that particular. That would be a ruling about something that's even more narrow than a specific element itself. It would just be too divided from an actual claim, where a summary judgment is related to a claim, not a specific factual or legal issue. That might be something more for a pre-trial discussion and not necessarily for summary judgment. I'd like the opportunity to brief that issue, but I just don't believe anything that narrow can be decided at summary judgment.
Okay. Anything else?
Yes, Your Honor. I just would like to point out section 2.23, and that Mr. Fatu was required to identify material omissions in the agreement. He didn't do it. That is his duty to disclose. So DG Lux is either included in the IP representations or Mr. Fatu has to present evidence that the omissions were not material. He has to do one or the other, and he doesn't do that. And without satisfying his duty to disclose, which again, Your Honor, the Supreme Court cases that have been discussed do not have this type of a full disclosure representation. He has made a representation that he made a full disclosure. It's a very rare thing in contracts. Mr. Fatu has not provided any evidence or made any sort of effort to the court to say that he has met that burden. And without that, there can't be summary.
Okay. Anything else?
Yes, Your Honor. If I can address some of these points quickly, I'm trying to get out of this full screen here. Oh, there we go. Hold on. A couple things, Your Honor. We cite to 6 Texas Supreme Court cases, and I want to, let's address the 3.06 issue really quickly. We don't agree, obviously, with what Mr. Mills has to say. But even if that were the case, we cite to 3 Texas Supreme Court cases: the JP Morgan versus Orca case, 2018, the Barrow Shaver case, 2019, in Carduco, which is Mercedes-Benz versus Carduco, that didn't even have a non-reliance provision in it. And the Texas Supreme Court still said, you got sophisticated parties who had, and we have an integrated contract, and you cannot bring a fraud claim, a fraudulent inducement claim, when you have the full ability to investigate and determine if the representations are true. And if you didn't protect yourself, then you're out of luck. That's 3 Texas Supreme Court cases argued or decided in nearly the same time. And then we have the other 3 Texas Supreme Court cases, Schlumberger, Forest Oil, as you mentioned, and IBM versus Lufkin, 2019, which all do have non-reliance provisions as Compass inserted in this agreement. And the court held the same thing. You cannot bring a fraudulent inducement claim when you have a non-reliance provision by the buyer. And
how do you deal with the argument that this is distinguishable because it's it's representations made within the contract?
Yeah, that's perfect, Your Honor, because guess what? All of those cases, or nearly all of those cases, had the exact same kind of language, except for the representations that are made in this agreement. I am disclaiming all other reliance. They all contain those types of languages. Every contract contains that type of language. So what they're saying is nothing special, Your Honor. And still the summary judgment was granted, and still, the seller was not allowed to bring a buyer was not allowed to bring a fraudulent inducement claim because, you can't introduce extrinsic evidence, as they're trying to do, to alter the terms of the agreement. So at the end of the day, the Texas Supreme Court cases are really, really clear on this point. This is nothing novel that we're trying to do here, Judge. This is textbook Orca, Barrel Shavers, Carduco, Schlumberger, Forest Oil, IBM, Lufkin.
May I, Your Honor?
Response?
Yes, Your Honor. Thank you. One consistent theme with all the cases that Mr. Fotu's counsel is referencing is the efforts of claimants to contradict terms of the agreement.
You cut out there, Mr. Mills. Say that again.
Sorry, Your Honor. One of the similarities of all the cases that were cited by Mr. Fotu's counsel is the want of the claimant in those cases to try to contradict what was in the agreement. That's not what we're trying to do. We're not trying to contradict anything. We're trying to provide context to the representations that are already in there, representations that have to survive for the intracontractual fraud. But we need the opportunity to provide definitions of those terms. And we talk about the know-how of BitBox or the processes of BitBox. What's the first question you're going to ask, Your Honor, or the first question a jury is going to ask? Well, what does that mean? What does know-how mean? What does processes mean? We need the opportunity to provide the jury and the fact finder with what that means. And that could be, if it's an interpretation, Your Honor, that's going to sit with you at the bench. If it's some other fact issue, then that will be with the jury. But we need that opportunity to provide some context in what those words mean and how they're defined. And when we talk about trade secrets and proprietary information, we need the opportunity, and we're entitled to the opportunity to provide that information and not be wiped out on disclaimer language that doesn't wipe out the intracontractual representations.
Your Honor, let me just say that the evidence, we filed objections to their evidence because they're not trying to add context, as they say. They're trying to add content. And that's very different. The parole evidence rule prevents them from introducing content that varies the terms of this unambiguous contract. And so we filed numerous objections on that. And I'll just say one other thing, Your Honor, on 3.06, Judge, at the very least, it's clearly an admission by Compass that they did not rely upon any of the, that they have a disclaimer of reliance. I mean, that's an admission, regardless of who they say that they made that representation to. And lastly, there are no intercontractual misrepresentations by Mr. Fotu.
Your Honor, if I may, then that's a separate issue, right? If those intercontractual, if there's no misrepresentations, he didn't provide any evidence of that. Those have to survive. And Your Honor, on 3.06, that's a contractual provision. It's not an admission. right? Even if someone did rely on something and then signed an agreement to say they didn't rely, it's not a matter of a fact question of whether there was reliance or not. It's just that they were just barred from bringing it. And 3.06 only allows Bitbox to raise that argument and not Mr. Fotu.
Your Honor, Mr. Mills' argument is just bootstrapping with respect to, they're just arguing that they assume he didn't make full disclosure, but he did. I mean, that's the whole point. He did make these full disclosures. He's not walking back from them. So there's nothing for Mr. Fotu to prove.
And if he's not walking back from the representations, then there's no summary judgment, Your Honor, because the intercontractual survives. There can't be.
And again,
Okay.
the Texas Supreme Court cases address those issues.
I'm going to go ahead and take this under advisement. What is this case set for trial?
May of next year, Your Honor.
All right. I'll get you an answer by the end of the, by mid-August.
Thank you, Your Honor.
Thank you, Your
All right,
Honor.
thank you, guys. And if you want to email me those PowerPoints, that might be helpful too. So email my court coordinator the PowerPoints.
Thank you, Your Honor, and I'll learn how to share a screen next time.
Okay.
Thank you, Your Honor.
Thank you.
No problem. Great to see you guys. You guys be safe, okay?
Thank you too.
Bye-bye.
Thank you. Okay, I think the next folks are here. Oh, where'd he go? There you are, Mr. Myers. Mr. Myers, who do you have with you today? You're muted, Mr. Myers.
Thank you, Your Honor. I have Greg Money and Dr. Mike Hill, in case the court wants to hear from them directly.
Okay, so this is how I'm going to kind of do this hearing today, just so we can, we'll go on the record. I don't want to keep anything off the record on this one. Mr. Myers, do you mind announcing the case name and the cause number?
Yes, Your Honor. This is the case of Wynn Oliver versus Juan Andreas Cuellar et al. The case number is DC 17-15831.
Okay, and Mr. Zaidi, if you want to go ahead and introduce yourself.
Thank you, Your Honor. Jib Zaidi for the plaintiff, Wynn Oliver.
Okay, and so we're here on two motions to strike experts. Is that correct, Mr. Zaidi?
That is correct, Your Honor.
This is not a motion to strike counter affidavits as to Mr. Money, correct?
That's correct. These are Dauber-Robinson motions.
All right, so let me just kind of ask you. I want to deal with Money first, and we'll hopefully do that one fairly quickly. So I guess my main question is, after In re Allstate, I know that's not a case involving Dauber, but does it make more sense to you for me to strike Mr. Money as an expert, or do you want him to allow him to testify live at trial? It creates an appeal point in my mind.
Your Honor, I don't think In re Allstate affected the Dauber analysis, and I do think that the methodology used by Mr. Money does not meet those requirements. So I would continue with my motion to strike him at this time as opposed to presenting him at trial.
All right, I will go ahead and strike Mr. Money as an expert in this case, but I do want to hear argument about Dr. Hill.
Your Honor, just for point of clarification, to protect the record, Mr. Money is here to testify. However, we did submit an affidavit pursuant to the court's request. I want to make sure the court has accepted that affidavit, and that affidavit will be part of it.
I reviewed everything. I don't know where the Supreme Court's going to go with this. I totally disagree with the In re Allstate case. Mr. Zaidi wants to take the chance and see what, I may ultimately get reversed on this, but I do think it's an open issue. And, but I appreciate you submitting everything, and we'll kind of take it from there. And I'm sure that there'll be additional guidance from the Supreme Court on this in the near future. So if there is any additional opinions that come out about these experts like Mr. Money, feel before trial, please bring that up to me. But at this point, I agree, and real estate doesn't apply, and I'm going to strike Mr. Money. But that doesn't mean I'm striking Mr. Hill, Dr. Hill. I apologize. And so let's hear argument on him.
Yeah, correct, Your Honor. I understand the court's ruling. I just want to be careful in terms of preserving my error for appeal.
Absolutely. You preserved error. I've reviewed the record. I've reviewed the affidavit. I reviewed everything. I'll take judicial notice of the entire file.
Thank you, Your Honor.
Let's deal with Dr. Hill. I think that's a much closer call.
And Your Honor, I have one more clarification on Mr. Money's motion. We had bundled, because they use the same methodology, Dr. Patel and Dr. Duvall into that motion. Since they're using the same methodology, are they also struck?
I don't see how I can strike them on qualifications. I think it's different. I'll strike to the extent that they rely on Mr. Money's methodology. I'll go ahead and strike them. But if they have any other basis besides what Mr. Money relied on, just relying on him, then they can be allowed to testify.
Understood. Okay. Thank you, Your Honor.
All right, let's get to Dr. Hill.
All right. May I share my screen, Your Honor?
Yes, go ahead.
All right. So, Your Honor, we're here on our Dawber challenge for Dr. Hill. If I can get this to start. There we go. Is that appearing all right for you, Your Honor, or is it?
Yeah, that looks great.
Okay. So, Your Honor, I'm not going to go over all of the Dawber considerations for the court. I'll just highlight the ones that we think are at issue in Dr. Hill's case, which is the extent to which the theory relies upon the expert's subjective interpretation, the potential rate of error, and the acceptance by the relevant scientific community. So in a nutshell, what the methodology is that Dr. Hill will take photos of a vehicle and that he will compare it to an exemplar vehicle, which should be the same vehicle, or at least a similar vehicle in a similar type crash, where the data about that crash is known. And so the thinking is, if we know the facts about this crash, we can then extrapolate to the one that we're looking at. From that, they'll take the speed and they'll plug it into the HVE program using the same variables and the speed that they've just calculated by examining the photos to get the delta V. Delta V is supposed to be the change in velocity that the body undergoes. They compare that to a study that provides delta Vs for different activities of daily living to determine the statistical likelihood of injury. Now, in this specific case, the methodology did not include any exemplar analysis of the defendant's vehicle. It does not include any measurements of either vehicle's dimensions. It does not include any measurements of the actual crushing or shearing that's done on the vehicles. It does not include any data that's downloaded. And importantly, in this case, where we have a patient or a plaintiff with significant medical history, significant relevant medical history, this approach does not take into consideration any of the plaintiff's pre-existing conditions, nor any of her body kinematics, meaning height, weight, sex, all of those things. So let's turn to the first piece of his approach, which is comparing the vehicle to an exemplar. Now, in this case, our client was driving a 2008 Scion TC. Dr. Hill says in his research and looking for an exemplar, he could not find one that was similar. So he relied on the Tanner study predominantly, where the exemplar vehicle was a 1983 Monte Carlo. Now, Your Honor, it's been about nearly 30 years gap between these two vehicles. A lot has changed in that time, including body shape, axle size, body shape, axle position, materials used. It's not even the same company. The area these are manufactured in is different. There's really no reason for believing that the 1983 Monte Carlo would function as an exemplar for the 2008 Scion TC. Additionally, he looked at the Bailey study. This was a little bit more downplayed. There was a second exemplar vehicle that he looked at. That one was a 1981 Dodge Aries. Same issues on that. There's no reason to think that a Dodge Aries from the early 80s would be a good comparison vehicle for 2008 Scion TC. So moving forward, he then takes the data that he's got from, this is what I would consider the eyeballing part of this process, where he compares the visual damage to the visual damage of a different vehicle. And he inputs this into the HVE program. Now, for whatever reason, Dr. Hill in this case did not have a Scion TC or a similar coupe that he could model in the program. So he instead used a Toyota Yaris, which is a hatchback. So when we're switching body types, we're also switching the physics of what's going on. Especially relevant in this case is the position of the back of the vehicle to where the tires are. In a hatchback, there is no further vehicle behind where the rear tires are. But in a sedan or a coupe like we have in our case, the wheels sit more towards the middle. Similarly, for the defendant's vehicle, GMC C7500, he used a generic box truck. In this case, we know that it was a water tanker and not just a box truck. So we know that there was different equipment there. I could understand how a generic box truck could be similar to a GMC C7500 since they are sometimes outfitted that way. But it's just another point where, you know, when you stack one assumption on top of the other and one leap on top of the other, the errors start compounding. Now, especially relevant in this portion of the analysis is that he cites to the Pierce study, because this is a side swipe where the lug nuts from the defendant's vehicles have left scrapes and shearing forces on our vehicle. The Pierce study provides the mathematics behind how to calculate speed in that circumstance. But critically, the study says you need the tire's rolling radius. And it's by measuring the cycles of the rolling radius that these equations come together. But in this case, he did not have the tire's rolling radius and he did not calculate it. So the study that he's relying on tells him that you're missing a variable. Even further, the Pierce study states that if one vehicle is stationary, that these numbers fall apart. It only functions when both vehicles are moving. And as he notes in his report several times, Miss Oliver testified that her vehicle was completely stationary. Finally, then, we turn to from going to the analysis of the vehicles to going to the analysis of the person. And here's where I would say that Dr. Hill's analysis doesn't actually help the jury, because he's not offering testimony on whether Miss Oliver or a person like Miss Oliver would get injured in this case. He's not testifying that she could not have been injured in this case. He's offering the testimony that generally less severe crashes result in less severe injuries, which is, I think, within the common understanding of the jury. This is the basis that they were previously, this group, Rimkus, was previously struck on in a federal court because the judge felt that it wasn't providing any enlightenment to the jury to say that less severe crashes cause less severe injuries. Now, the defense has put some numbers forward saying that this approach is 90% accurate. However, that falls apart when we look at the actual numbers and the data. The Comir study, which was cited by Dr. Hill in this case, says that when there's a sideswipe event, delta V, which is the variable we've been looking at, is not as robust an injury indicator. So already there's a bigger margin of error when we're dealing with sideswipes. When we look at some of the other studies that are looking at rear ends where delta V is supposed to be the hallmark number, it tells us that 80% of injuries occur in crashes that the delta V underestimates. He further points to the Allen study. This is what he uses to compare the delta Vs to activities of daily living. To say, for example, if you plop down in a chair, your body would be moving at X delta V, and if you sneeze, your spine will be moving at Y delta V. Now, that study points out that there are many factors that go into that are not included in the study, including musculoskeletal stress, social, cultural, psychological, legal, nomogenic issues. And the study says that's beyond the scope of what we're trying to do here. We're just trying to provide some analysis of some activities of daily living. The study indicates that it should not be used for injury analysis, which is exactly what it's being used for here. Finally, Dr. Hill states that one of the reasons that he found that Miss Oliver was not injured in this crash was that there was no mechanism for forward bending of the neck, and he cites to the Fitano study. Now, the Fitano study is one of the few studies that involves a commercial vehicle, a larger vehicle, sideswiping a passenger vehicle, and they did that test 3 different times. And I pointed out to Dr. Hill in his deposition what you see here in the bottom right, which is in one of those tests, the driver's head did move forward. So there was forward movement in a sideswipe crash, which he had just said wouldn't happen. Finally, Your Honor, there's been some new research in biomechanics that have looked specifically at this methodology of comparing delta V to activities of daily living. And they found that this is an invalid method for evaluating injury causation. It grossly underestimates injury severity and injury causation. I believe the number that they gave was 2,000%. I think when you couple that built-in error rate with all of the assumptions that have been taken in this case, using the different type of vehicle, using only one exemplar photo comparing to vehicles from the 80s, we just see that these are not reliable opinions. The methodology to get there is not reliable. And so for those reasons, we believe that he has not met the Dahlberg-Robinson standards.
Okay, response?
Yes, Your Honor. I just want to point out first and foremost that everything that Mr. Zadie, his argument is premised on evidence and studies that are not before the court. They don't have their own expert to contradict what Dr. Hill is saying. So to the extent that they are relying on studies that are not properly before this court, then obviously we would object to that, and that shouldn't be considered, and it shouldn't be used to support their argument. What I will say, Your Honor, is the fact that that Mr. Zadie has pointed out that Dr. Hill did in fact rely on studies and articles goes to the very point that his opinion is reliable. They may not agree with what Dr. Hill says. They may not agree with what the reports that he relies on dictate in this case, but that's not what we're here about, Your Honor. What we're here about is, number one, is Dr. Hill qualified? It seems to me like he's qualified and nobody's questioning that point. Number two, is the information that he has to offer relevant? Does it make the existence of a fact more or less likely in this case? One of the key questions in this case is whether the plaintiff's injuries are related to this accident. He's offering testimony directly related to that issue. Therefore, of course, what he has to say is relevant. The final point, Your Honor, is reliability. Is Dr. Hill's methodology reliable? Can I share my screen, Your Honor?
Well, let me ask you, you can, but let me ask a question. Has Dr. Hill ever been struck as an expert before?
He has not, Your Honor.
In any court?
He has not, Your Honor.
Mr. Zadie, is that right?
The order I have, I don't believe goes to Dr. Hill. I think it goes to the other expert that reviewed the report, whose name is escaping me at the moment.
Your Honor, I would further say that Dr. Hill is not testifying in this case that the plaintiff was not injured. What Dr. Hill is testifying to, let's step back for a minute and let's focus on what he's testifying about. What he's saying is that in this particular type of accident, which everybody admits is a sideswipe, in this particular type of accident, these are typically the types of forces that a person in a vehicle will experience. That's first and foremost. Secondly, he is testifying that when you look at the injuries that the plaintiff has experienced and alleges that was caused by this case, the types of forces that typically cause those types of injuries do not appear in this case. That's what the scientific literature supports. That's what Dr. Hill is relying on. And to the extent that the plaintiffs disagree with that particular conclusion, they're free to attack him at trial and point out all of the deficiencies they claim. But what's key, Your Honor, is Dr. Hill's analysis reliable? And I have my PowerPoint. I have Dr. Hill here prepared to testify. I think that after you hear the PowerPoint, after you hear Dr. Hill testify, you will find that his methodology is reliable. Plaintiffs may not agree with it, but it's definitely reliable. I would also point out, Your Honor, that last week we submitted an affidavit from Dr. Hill outlining what he will testify to today, in anticipation that perhaps the court would have preferred that we included Dr. Hill in addition to Mr. Money. So that is available. It's in the court's file. It was filed last week.
You know what day that was filed?
It was filed by me on Wednesday morning, and it was accepted on Thursday.
Okay. Go ahead with the PowerPoint. Or you were going to share screen something, and I kind of diverted you. Whatever you were going to share screen.
Yes, correct, Your Honor. I'm going to do it right now. All right. Can you see that, Your Honor?
I can.
Okay. So again, the question is, there's no question Dr. Hill's qualified. There's no question that what he's going to be offering is relevant. The question is whether it's reliable. And I am going to his opinions are based on 72 relevant citations in peer-reviewed scientific literature and the relevant methodology. When you look at what the plaintiffs are arguing in this case, they're arguing whether his opinions are correct, whether his opinions are true. They're not arguing that his methodology is unreliable. I'll point out, Your Honor, that they point out in terms of objectivity, he relied on 6 color photographs of Miss Oliver's Scion. That's true. Statistical data on the Scion and Quellar's GMC. That is true. Google Maps. That is true. And Mr. Quellar's and Miss Oliver's depositions. If you look at the book that controls this type of scientific analysis, traffic collisions and investigations, you can see that each of the elements that Dr. Hill relied on are fundamental to the to crash analysis. And from his methodology, he is tracking consistently with what the body of science says he should be doing. There is questions of whether or not it's not as much as it is he looking at the photographs and making a conclusion, oh, based on these photographs, this wasn't a severe accident. That's not really what it is. What he's doing, Your Honor, he's looking at the photographs to establish what we already know, which is what both people who were witnesses to the accident have testified to. It was a sideswipe accident. He uses the photographs to verify that. He uses the photographs to help him establish exactly the fact that the vehicles came in contact in a shearing type motion, and that the vehicles came to a stop in the process of that shearing stop type motion. He's not saying that based on these photographs, there were no injuries in this case. That's a misstatement of what his opinion is. Now, with respect to the crush elements from photographs, what Dr. Hill has pointed out in his deposition is that the crush estimates the error rate is not 30% that plaintiff's counsel is arguing for. What it does is that it provides, in terms of the measurements of the actual shearing along the sides, that varied by 30%, but it did not impact the underlying analysis that a review of the photographs showed. And that's important for the court to recognize. So then when we talk about, they say, to be clear, Dr. Hill did not conduct a measuring of the crush or shearing involved. He simply compared the damage he saw in the photographs. And then we get into the issue of whether or not he used the proper vehicle. And he says in his deposition testimony, well, of course, as we discussed earlier, they're never going to be the exact same vehicle, right? But we know they do have some semblance here. And you know, Bailey looked at several different vehicles during the test. And I know that study was some time ago, but you have to consider, you know, all the aspects of the case as well. And that's the classification. It's a side swipe based on the angle, based on tourist paper, based on the CDC or crush information classification of a side swipe being in contact within, I think, 4 to 6 inches of the side of the vehicle. All of those things point to this accident was a side swipe. Plus, there's the studies by Cormier looking at lug contact as well. So, Your Honor, the point is he's not looking at the photographs to reach the conclusion this wasn't a severe accident. He's looking at the photographs to determine what type of accident it was. And then once he knows what type of accident it was, he can then go and he can evaluate the type of forces that would typically be consistent with this type of accident. That's what Dr. Hill's doing. They make the plaintiffs make a big issue about him not going to the scene of the collision. Well, the problem with that, Your Honor, is the scene of the collision is while people are there and while the vehicles are still there. That did not exist in this case. Both vehicles were driven away from the scene. Years passed, lawsuit was filed. So the scene would never have been available to Dr. Hill, and nothing that he could have done to go and inspect the scene would have made any impact on his decision in this case. And in fact, no one could go and see the scene and come up with a contrary conclusion than what Dr. Hill is offering. So plaintiff's counsel makes a point of saying that Dr. Hill used a Toyota Yaris instead of a Scion like the plaintiff was driving. Well, that subject came up in his deposition as well. Plaintiff's counsel asked, so you're saying the shape of the vehicle wouldn't change your analysis? Dr. Hill specifically addressed, well, no. If it was a meaningful difference, then it would change the analysis. But what HVE considers is the size to have crush stiffness, the vehicle to have a weight, and to have it basic dimensions. So what Dr. Hill did is he took a vehicle that was of the same weight, the same size, and used that in his analysis. He had all of this information available. It says, so your testimony to the jury is that these are just cosmetic and the model that you used is not important. Dr. Hill answered specifically, no, that's not what I said. I just said the look of the vehicles is not what's relevant. What's relevant is the masses, the speeds, the accelerations, the delta V, that sort of thing, and the stiffness of the vehicles, which is all based on published data. You can see where plaintiff's counsel says, okay, then I also saw in the model that the truck was modeled as a box truck. And you would agree with me that we don't have a box truck in this crash. Dr. Hill again specifically answered, yes, that's correct. Yes, these are really just I would change the color too. You know, these are just cosmetic things. What's important is you know that the vehicle weights are and what the vehicle dynamics are. Again, Dr. Hill specifically addressed the exact reasons why plaintiffs are taking issue with his opinions in this case, and keeps going back to what the fundamental basis for this type of analysis is, which is the weight and the dynamics. That's what's important. And then it says that notably, this is from plaintiff's motion, notably, despite knowing from Mr. Quellar's deposition that he had an empty water tank on the back of the truck, Dr. Hill did not calculate the weight of the tank. That is a flat misstatement, Your Honor, in that, well, I take that back. It's not a misstatement, but it is somewhat misleading because what Dr. Hill did calculate is what the weight of the tank would have been had it been full of water. Not an empty tank, but had the tank been full of water. That is what Dr. Hill's vehicle dynamics and his analysis is based on. So they can say, yes, he didn't calculate the weight of the empty tank. And no, he did not calculate the weight of the empty tank. He went better. He went better and gives them the benefit of the doubt and calculates the weight of the tank if the tank were full of water. That's more meaningful in terms of his analysis, and his analysis takes into account the vehicle weight with the full tank. It says, likewise, he did not calculate the truck tire rolling radius. And you can see from Dr. Hill's testimony, in this case, it's clear that there's not long patterns on the side of the vehicle, but there's not a lot of circular motion. The tires only rotate a little bit during the time of contact. The reason that's important, Your Honor, is because Dr. Hill's not using it for any other purpose than to show it was a sideswipe accident and that the vehicles came to a rest while they were still in contact with one another. That's consistent with the scientific literature, and it's reliable. So from plaintiff's motion to strike says that they take issue with Dr. Hill saying that he did not analyze lug content. Well, he certainly did from his report. It's in his report, and it was in his deposition. There's evidence of lug contact to the quarter panel of the Scion. He cites the Cormier study. All right. And then he cites specifically from the article and talks about the nature of the interaction between the two vehicles. Side swipes are characterized by a sliding interaction, characterized by side swipes. Using delta V and acceleration is difficult. The reason why, Your Honor, just to back up for a moment, in a side swipe accident, delta V and it doesn't come into play is because you don't have a T-bone collision or a bumper collision. You have more of a shearing motion. And so you're not going to see the same delta V forces in a side swipe accident. So that really comes from the fact that there is relatively low difference in the speed in which the vehicles are traveling. They come in contact, and in this case, they came to a stop. And you can see that Dr. Hill's conclusions rely on the studies that are cited in the PowerPoint and the studies that are cited in his report. So he's relying on published peer-reviewed literature. He's not just making it up, Your Honor. So in the crash analysis, they take issue with the fact that that he did not do any analysis as to the impact of plaintiff's car on a curb. Well, from his report, and you can see the Google photos at the time of the accident, which Dr. Hill authenticated, show there was no curb at the location where the accident occurred. So for them to say, and again, they can take issue with it, but the question is it reliable? Is it reliable to go to Google and look at historical photos at or around the time of the accident to get the condition of the road? Clearly it is, Your Honor. Clearly that is a reliable source for Dr. Hill to rely on. So that's why Dr. Hill can say there's no evidence of a curb strike, because there was no curb. Plaintiff testified that she remembered going up on a curb, but the reality of it is Dr. Hill looked at the Google photos and there was no curb for her to go up. That's his opinion. Now, that's based on data. That's based on Google photos. They can certainly attack him at trial if that's the case. If they want to put up Miss Oliver's memory as to what the data, what Google Photos shows, we can certainly, I can see how they certainly have the right to do that. Next, we look at, they tacitly admit that HVE is the generally accepted software in the accident reconstruction community. That right there establishes it's reliable, all right? So what they're now arguing is that Dr. Hill somehow did not input reliable and relevant data. That's different than saying that the methodology that he used was not reliable. They are acknowledging that the methodology is reliable. They're taking issue with the inputs he used in order to fulfill the requirements of that methodology. So you can see that the published stats for the vehicle that the plaintiff was driving comes from Expert Auto Stats. This was included in Dr. Hill's report. Then he goes on to show in his report the HVC source that calculates the variables, the different masses involved in this type of accident. And you know, for the plaintiff to argue that, well, a hatchback is different than a Scion, where is the testimony? Where is the evidence to support that argument? They've not brought it. It's just plaintiff's counsel arguing. How do we know? How do we know? Because Dr. Hill is saying that the Yaris is a suitable comparator for the Scion. Where is the evidence to contradict that statement? It doesn't exist. Again, he's using the methodology that is required by his science. They may not like it, or they may disagree with the way he goes about inputting the data, but that's not the same as saying that the methodology he used is unreliable. So again, they go back to this issue because this issue, quite frankly, Your Honor, gains traction with the court, right? They're trying to make this about Dr. Hill looking at photographs and concluding that this accident wasn't severe. That's not what he's doing. That's not what he's doing in this case. from a high level perspective, he's looking at this accident, the way it was described by the plaintiff, the way it was described by the defendant, and he is reaching conclusions about the types of forces based on this type of accident that a person would experience in the plaintiff's position. From that, he then looks at the injuries that the plaintiff is complaining about and reaches the conclusion that those types of forces necessary to cause those types of injuries are not present in this type of crash. That's what Dr. Hill is testifying about. Clearly that's relevant and it's reliable. So this is where we get into the injury consistency analysis. And we talked about this before because we talked about it, that delta V in a sideswipe event is not as robust as an injury indicator as other collisions. And Dr. Hill agrees with that. The reason, Your Honor, the reason that delta V in a sideswipe event is not as robust of an injury indicator is because the delta V tends to be lower in a sideswipe event than it is in a bumper to bumper or a T-bone accident. That's what Dr. Hill testified to. He agreed with the plaintiff in that sense. And so no one here is contending that this was a bumper to bumper or a T-bone accident. Everybody admits this is a sideswipe accident. So then we get into the Fitano study. The issue with the Fitano study was that all of the, in the Fitano study, Your Honor, just to go back and remind the court, the Fitano study is the study that said that in a sideswipe incident, there was one example where there was head movement in a sideswipe accident. Well, what's interesting, Your Honor, is that the Fitano study involved what we call crash dummies, not real people. So when you have crash dummies, they don't typically have the same muscular support that would prevent a head movement going forward in a sideswipe type incident. Dr. Hill testified about that and specifically pointed out in response to the questions from plaintiff's counsel, why it is that the Fitano studies finding that there was one example where a head moved forward doesn't really apply when you're talking about real people. Again, they can argue that that's not a valid way or a valid reason, or it does, or that the jury should then not take Dr. Hill's conclusions for what they're worth. But that doesn't have to do with the fact that Dr. Hill's opinions are relied on the science and the methodologies he's using. They may not like the results of his conclusions, but that doesn't mean that his conclusions are not reliable. So there are other studies, the Tanner study, which talks about specifically the impact or the forces that a sideswipe accident will have on the occupants of the vehicle. And again, this is what Dr. Hill is relying on, and I don't need to go through and talk about what these reports say. The question is, did he rely on published reports? Yes, he did. Are these reports accepted within his industry? Yes, they are. So they talk about this 80% number, and there is no 80% error rate. That is not an error rate, what they're talking about when they're talking about the Nolan study. In their motion to exclude Dr. Hill, they say his conclusions result on an approach that was found to have an 80% error rate when applied to real world situations. That is a misstatement, Your Honor. That is not what the report says, and that is not what Dr. Hill said. So if you look at what is actually in the Nolan statement, it says results indicate that for cars, the Institute's 64 km/h frontal offset test represents a crash severity that encompasses about 80% of all real world crashes with AIS-3 or greater injuries. Somehow, from that statement, Your Honor, plaintiffs have put in this motion that the methodology in the Nolan study has an 80% error rate. That could not be more of a flat out disconnect on a good day or a flat out misrepresentation on a bad day. Finally, what's important is that what's important, Your Honor, is Dr. Hill didn't even rely on the Nolan study when he did his analysis in this case. Plaintiffs are certainly putting forth the argument that Dr. Hill has relied on the Nolan study, and the Nolan study has an 80% rate. I just go back. There's not an 80% error rate in the Nolan study. That is not what is being talked about in the Nolan case. But more importantly, Dr. Hill did not rely on the Nolan study, and specifically pointed out why in his testimony. Well, he didn't. He says the article sounds familiar. I believe he's read it, but he did not rely on it as part of his conclusions. Now, we talk about the latest article, right? And again, there's no one here to sponsor this article. There's no one here to explain to the court what this particular excerpt means. Plaintiffs have not designated someone who can talk about this, but in a sense, Your Honor, what we have is a paper that is contrary to what Dr. Hill's testifying to. That doesn't make Dr. Hill's methodology based on years of scientific literature, does not make Dr. Hill's analysis or conclusions unreliable. And plaintiffs are certainly free to cross-examine Dr. Hill about this article. But here's the thing. The type of accident that is in the article that has been cited by the plaintiffs, for which there is no sponsoring witness to testify, was rear impact crashes. This is not a rear impact crash, Your Honor. Everybody acknowledges it was a side swipe. So the article, the latest article that plaintiffs want you to consider that they believe undermines Dr. Hill's reliability did not involve a side swipe. It involved a rear end accident. So what is relevant, Your Honor? What's important for Dr. Hill is what type of accident was it? It was a side swipe accident. When he is able to determine the side swipe, that it's a side swipe accident, that leads him to, on his methodology, it leads him to a different analysis in terms of what are the types of forces that an occupant would experience in a typical side swipe accident. So if you're looking at front end accidents, or if you're looking at side collisions, those have nothing to do with the type of accident we're talking about here. And what Dr. Hill is only focused on as it relates to the Bailey study was those parts of the Bailey study that dealt specifically with the side swipes. So then when you get down to it and you talk about reliability, this is a Google search, Your Honor, vehicle accident reconstruction, 146,000 results, right? Which are those that are reliable? Well, the ones that are reliable are the ones that have been accepted by the community that Dr. Hill is a part of, and he has pointed out in his report and in his deposition. So his analysis is consistent with what the professionals in his line of work do. His analysis is reliable. They may disagree with it. They may think it's wrong, but the question is, does it satisfy Daubert and Robinson? Yes. He's qualified, it's relevant, and more importantly, Your Honor, it's based on scientific method and in literature that has been accepted in this area, in this field for decades. Now, Dr. Hill's here. He's here. Go ahead, Your Honor.
No need for that. Anything else?
That's all, Your Honor.
Okay, response.
Thank you, Your Honor. I'll try and make it brief, Your Honor. The most egregious part for us in this analysis, where we think that his approach was the weakest, was in the comparative damage analysis. And my opposing counsel here has just said several times in his argument that the comparative damage analysis was not for injury, was not for damage severity, it was not for damage severity, it was only to determine the type of the crash, that it was a side swipe. He keeps saying that that's not what he was doing. And that is, in fact, not accurate. And if we can't agree on the methodology, we're not going to make any progress here. I'll show you from Dr. Hill's report. the very first thing he discusses in his methodology is the comparative damage analysis. And he says, a comparative damage analysis was conducted to assess the severity of this accident by comparing the damages sustained by the subject vehicles to damage sustained by exemplar vehicles, which is the exact thing that opposing counsel said isn't happening here. So I would say that if once we get on the same page about what is in fact happening here, and that this is the baseline, the starting position of his approach, then we can see why there are reliability challenges when you're using an 83 Monte Carlo as the exemplar for a 2008 Scion. You're just not getting off on the right foot.
Why doesn't this go to the weight as opposed to his ability to testify?
Well, we're not challenging his qualifications, Your Honor. We're challenging the reliability of this analysis. And as has been said in his report, he was looking for a comparable vehicle, that one that had the same, was in a similar crash where the speed and other functions were known, and that he could not find one. Right here, a search for the same design generation Scion resulted in no relevant cases with comparable damage. So in the data that he provided, he instead substituted an 83 Monte Carlo. That's just not a reliable approach. He's pointed out here that there was an effort made to find a comparable vehicle. You wouldn't do that if it didn't matter. Your Honor, further, I'd point to the studies that, especially the Fitano study that opposing counsel has raised. These aren't studies that I brought to the table. Dr. Hill cited them in his own report. Especially relevant to the injury causation is this acceleration perturbations of daily living, which says by its own terms that this study did not compare or factor the various issues that influence the outcomes for potential injury. It's not what the study is for. He also cited the Nahum study, which says similar things. Occupants often bring to an accident significant pre-existing medical problems. Diseases such as osteoporosis and degenerative problems of the spine modify the response to trauma. They must be considered when human tolerance levels are factored into the injury reconstruction analysis. So the reason I'm bringing these reports up to the court's attention is because they're relied on by this expert, and the reports themselves say, don't use this for this purpose. This is not what we're for. Or if you are going to do an injury analysis, you must take into account these other factors that are relevant for this person. And that's what's relevant to the jury. It's not whether any random person would have gotten injured in this wreck. It's whether when Oliver got injured in this wreck that they'll be asked to decide.
Anything else?
That's it, Your Honor. I'm just figuring out how to stop my screen share.
No problem. Okay, I'm going to take this under advisement, and I'll try to make a decision at least a week before trial. You guys are set on August 17th, right?
Yes, Your Honor.
Okay. Thank you, guys. You guys be safe, okay?
Thank you.
Thank you, Your Honor.
I'm going to take a real quick break. And
Your Honor, did I provide you a motion, sorry, an order for the first motion, or do you need the court us to do that for the court?
Yeah, if you need to get, you need to go ahead and get that to me if you haven't already. So go ahead and email my court coordinator and make sure it says on July 26, 2021, the court struck Mr. Money, and then as to the other two experts, struck any, to the extent they relied on Mr. Money's analysis, they're struck any other, but if they have their own independent basis, they can testify.
Got it. Okay, I'll put that in there. Thank you, Your Honor.
I'll be right back.
Thank you.
Hello, Mr. Woodards. Can you hear me okay?
Yeah.
So I was taking a look at your default judgment. There's a number of technical problems with it. I'm not trying to be critical, but everyone has to comply with the law and the rules. The first thing is it doesn't look like you ever served the defendant. Was the defendant ever served?
I turned some papers in. I served the defendant through the courts.
I don't see that there's a return of citation on file, and that's the first thing we have to look at. It says that according to what I'm seeing here online, Rhonda, if you're online, can you check this? I don't see on my side that there's been a return of citation, which is kind of required, or which is required. And let me kind of show you, sir, just so you kind of see what I'm talking about. So this is your file. You see this, Mr. Woodards,
Yeah.
I'm sorry.
Yeah.
And you see they issued citation back on 6/8/2021 for your petition, and then it was returned unserved. Do you see that?
Yeah.
So what would normally have to happen is that you'd need to have a return of citation on file before I can even consider the motion for default judgment. And the reason for that is that we have to make sure that they've been served so they have notice of this lawsuit. And so maybe they have been served, but it's not been, the return of citation has to be on file for at least 10 days before I can consider the default judgment. Does that make sense?
Yeah. So pretty much I just need okay.
Well, that's the first step is you have to get that on file. And then and Rhonda's confirmed it has not been served, which didn't look like it had been. And then there's your default judgment itself. It has a lot of problems with it. It has to have evidence of damages. It has to have what's called their certificate of last known address that has been filed. It has to have, there's about 10 or 15 other things that need to be included in your default judgment. Have you been to the law library to try to get a form for this?
Yeah. Actually I have, yeah.
This is what the form looked like?
Well, actually I print that one out like myself.
Okay, I would go to the law library and ask them for a form on how to file a motion for default judgment and an order for default judgment after you get service if they don't file an answer. And then I can take a look at it, but this doesn't comply with, there's about 10 to 15 technical violations. I told you a couple of them in this motion, and there is no order. And so if you want to do it, for me to be able to consider it, it has to comply with the rules. So I would go down to the law library at the George Allen Courthouse, and they can help you point you to a form book that can give you some guidance on how to do this. Does that make sense?
Yeah. I'll do that sometime this week.
Okay. All right. Well, you be safe, and you have a good day, and just to try to get that in, you have a dismissal docket coming up, and try to get that in before your dismissal docket. Okay.
Yeah. I appreciate it.
All right. You have a good day, sir.
All right, you, bro.